Hello there. Welcome to my video to try and summarise the law of nuisance. Nuisance is a tort law. It's quite a big area of law, but if you understand negligence, okay, you should be quite confident with nuisance. There is a few types of nuisance actually. We have statutory, public and private. So statutory we don't need to go into. It's where you can complain to the council about noise, smells, smoke, pests, and then the council will sort it out for you. There's another quite small nuisance which you may need to discuss, particularly if you're writing an essay on nuisance, for example, which is public nuisance. So as the name suggests, public nuisance is a nuisance which affects the public, or at least a large group of it. So my typical go-to example for this would be music festivals. The noise, the pollution, the inconvenience from that festival would probably affect a large group of people in the area. So for example, if you think of Glastonbury Festival, it's going to affect a lot of people in Glastonbury. Now, if something is a public nuisance, the Attorney General brings a case on behalf of them all to try and get that nuisance stopped. So that might help an individual claimant. So for example, if a case was brought against Glastonbury Festival and the Attorney General won, that would help an individual person living in Glastonbury because then the festival would stop. However, if that person wants to get compensation, they have to sue as an individual. So if a person feels like they've been affected by Glastonbury Festival, for example, they would have to sue the organisers. And what they would have to do to be able to do that in public nuisance is show that out of everybody in Glastonbury, they have been affected worse than others. In other words, their case stands out from everybody else and that's why they deserve compensation. We're more concerned with the law on private nuisance, which is essentially one individual suing another because what they're doing on their land is interfering with their peace and quiet and enjoyment of their land. So essentially we're probably looking at neighbours here or people living in close proximity to each other. So before we break down the definition of what a private nuisance is, I thought I might jump a little bit to the defences and remedies because these tend to get overlooked by students, especially as we're running out of time when we're writing an answer. So it might be useful in your AO1, your knowledge and understanding. You might want to go through these earlier on. So some of the key defences that are quite unique with nuisance are statutory authority, planning permission and prescription. So statutory authority is where Parliament or an Act of Parliament has given permission for a certain activity to go ahead, and then any nuisances are just part and parcel of that and people must put up with them. Classic example of this is railways. So railways are put there by authority of Parliament. They are allowed by Parliament, and unfortunately we just have to put up with the noise and the fumes and things like that. That's because Parliament has supremacy, so their laws outrank everything else that we can throw at them. Now, students tend to get this mixed up with planning permission, which is given by local councils. Now, it's a similar mechanism. A council gives someone permission to do a particular activity. Parliament gives someone permission to do a particular activity. The key difference is that planning permission is just given by local councils and therefore it doesn't have parliamentary supremacy. So while planning permission allows you to do an activity, it does not permit you to create a nuisance. You're still responsible for that. So for example, if you get planning permission to build a conservatory on your house, all the council is doing is allowing you to build. They are not allowing you to make lots of noise, to create lots of pollution. If those things bother your neighbour, you are responsible. We saw this in the classic case of Wheeler versus Saunders, where the defendant was given permission to open a pig farm. That had planning permission, but unfortunately that didn't also permit the smell and the noise from the pigs. So the defendant had to take responsibility for that himself. Finally, we have prescription, which is quite an unusual defence for nuisance, which is the idea that if you've been making a nuisance for 20 years or more, then a person loses the right to complain about that. And I think that's fair. If something's been going on for 20 years and you've not made a complaint, it's probably not that bad. Now, that timer starts ticking from the moment the claimant becomes aware and it starts bothering them. And that was a bit unfair. We saw this in Sturgis versus Bridgman, where the sweet shop had been there for a long time, but the doctor's surgery just opened a new room nearby. Now the vibrations from the machinery in the sweet shop bothered the doctor. Unfortunately, even though that sweet shop had been there for a long time, they tried to argue prescription. We've been here more than 20 years. The court said that clock only starts ticking when the doctor is bothered, so it started ticking when he built the new room, so they had to stop. Now, what remedies might a claimant ask for in response to the defendant creating a nuisance? Well, don't automatically jump to compensation, which is normally the main sort of remedy that you get in tort law. Actually, probably the main thing that the claimant wants is an injunction. Now, an injunction is a court order to either stop an activity altogether or to perhaps limit it, maybe to certain times of the day rather than at night. Now, an injunction is really useful if something is still ongoing or might happen again. So, for example, you might ask an injunction to stop building work that is ongoing, or to limit it so that they have to stop before a certain time at night. Injunctions aren't particularly helpful if the nuisance has been and gone. So, for example, if the building work is all finished, there's no point asking them to stop. That's where compensation might come in a bit handy. Compensation is an apology for the claimant for having to put up with that nuisance. So, as I said, it's useful for things that are already done and over with and they won't occur again. Compensation is also increasingly being used as a tool by the courts to reach a compromise. So it might be that we have an activity that has some social benefit that we can't really stop. We can't stop the defendant doing it, but we want to apologise for the claimant for putting up with it. And we saw that in the case of Dennis versus the Ministry of Defence. We have to allow the Ministry of Defence to train Harrier jet pilots. So the court didn't want to stop the noisy flights from happening. But the Dennis family were being inconvenienced by this. Apparently the sound levels were like a high-speed train going through your living room. So the courts felt bad for the Dennis family. So rather than telling the RAF to stop flying, the Ministry of Defence to stop flying, they had to pay £10 million to the Dennis family, which wasn't actually as much as they were asking for. Also, it doesn't solve the problem. Having a big bag of money is nice, but it's not going to stop that airplane noise. Finally, a more rare remedy is a self-remedy that you wouldn't necessarily go to court for, and that's abatement. Now, abatement is a difficult remedy. Abatement is where you stop it yourself. So, for example, you would go onto your neighbour's property and turn off the music, stop the sound, prevent the smells, etc. Now, the problem is, if you don't have permission to go onto the land, you could also be sued in trespass. So abatement can be quite tricky to do. You're best off sticking with court remedies like injunction or compensation. Now, if you're answering a nuisance scenario answer, you would normally also suggest the best remedy that the claimant would go for. So what have you got to prove? So if you can learn the Winfield definition of private nuisance, then you essentially have a checklist to work your way through in the exam. So it came from a book written by a professor called Winfield. And he said it's the indirect, intentional, unlawful interference with the enjoyment or use of land or of another. So I've just rejigged that a little bit and I'll explain why. I think it's easier to get some of the smaller elements done first before you forget them, before you get into the meaty part of your essay. So let's go through some of the more straightforward points here. It has to be indirect, intentional, there has to be some sort of interference, what type of interference, it has to be with the land of another, and the law has to see it as unlawful. So first off, indirect is basically distinguishing it from trespassing. If you even touch another person's property, that is trespass. So it's just a different area of law that you'd sue under. So nuisance is where you don't touch or go on to the claimant's land. That's why we tend to see things like noise, smoke, smells, vibrations, things like that. They're doing things on their property which travels and indirectly affects the claimant on their own land. Next, it has to be an intentional activity. Now, it's not intending the nuisance. So for example, if you have a barbecue in your back garden, the smoke and smells from that barbecue might create a nuisance. Now, that is intentional. You may not want to annoy your neighbours. In fact, you might be mortified if you know that you're annoying your neighbours. But the activity, the barbecue, is intentional. It's not accidental. You know, it's not like, for example, if a shed set fire, that wouldn't be a nuisance because you haven't set fire to it on purpose. It's unintentional. So you have to be doing an intentional activity. So that could be building a conservatory. It could be manufacturing in a factory nearby. Now, the law says there has to be some interference with the claimant's property. Now, interference is measured in a couple of key ways. One way it is not is personal injury. So if you've been injured by vibrations, maybe noise, you've gone deaf, maybe you've had some sort of allergy to a smell or smoke, those things can't be claimed for a nuisance. A claim in negligence would be more appropriate. So what does it have to be? Well, property damage. Damage to your property is pretty much automatically a big no-no under nuisance law. Why should what you're doing on your land damage my things? So if my things were damaged, then you can claim. In the case of Halsey versus Esso Petroleum, the fumes from the petrol depot stripped the paintwork off his car. Why should you put up with that? That would clearly be unreasonable. That would clearly be a nuisance. As well as property damage, you might be able to sue for something called loss of amenity. Now, loss of amenity is the enjoyment of doing something that you were able to do in your property that you can no longer do. Key example would be things like sleep. It could also be, I don't know, the peace and quiet of reading a book, for example, being able to watch TV, being able to live your life. Now, those things are harder to measure, they're harder to quantify, and we do have to put up with a little bit of give and take, which I'll explain a bit more later. But essentially, the more serious the interference is, the more likely you are able to claim. So personal injury is a no-no, property damage is a yes, and loss of amenity is a bit of a question mark. What are you suffering? What can't you do? How bad is it? How bad is the impact on you and your life? The other thing is that it has to be with the enjoyment of use of your land, so the land that belongs to another. So that means the claimant must have a proprietary interest to claim in nuisance law. So proprietary interest means you either own the property or you are the main tenant, you rent it. So for example, lodgers who sublet would not be included, children would not be included. So those people might have to bring a claim under human rights law instead, because under Article 8, you're entitled to a right to a private and family life. To sue under nuisance law, you've got to be the owner or the main renter. And we saw that in the case of Hunter versus Canary Wharf Tower. Now, they were unable to win anyway because their loss of amenity was not serious and recognised, and the loss of the TV signal wasn't bad enough. But also a lot of the claimants didn't have a proprietary interest, so they wouldn't be able to sue in the first place. Right, even if there has been an indirect intentional interference with the use and enjoyment of your land, so for example, the neighbours are playing music and you can't sleep, the court has to deem it as an unreasonable interference. That's what unlawful means here. And this is based on the idea of give and take. We live in a very busy society. The law recognises that not everyone can be silent little mice, and there has to be a bit of give and take. So for example, if you live in an apartment, you may make noise, you may play music, you may have your TV on, you may have your hairdryer blasting. So will your neighbour. You know, you can't go banging and shouting about every little bit of noise because you probably make noise too. The law expects give and the law expects take. So you have to put up with a little bit of noise, a little bit of interference if you live in a busy society. Where the law says it's unlawful is if it's unreasonable to put up with. You've overstepped a line and it's not reasonable to ask people to put up with that. How do the judges decide that then? Well, there is a number of things that they need to take into account. I think these are mostly really common sense, really quite straightforward. So first off is location. And I suppose if I was going to give a little hint, what I'd be looking at here is whether it's normal for the location that you are in. Is it a normal expected noise? So for example, chickens crowing in the countryside is pretty normal and expected in that location. Move to the countryside, you might have to put up with a bit of chickens. However, if you're in the middle of a city block, that's probably not normal and probably not what you would expect, but you might have to put up with a bit more traffic noise, for example. If we have factories in an industrial location, again, it's kind of expected. It's kind of reasonable to put up with some factory noise if you move to an industrial estate. Then we have a look at time of day. So common sense, really straightforward. The later it is at night, the less reasonable it is for you to put up with it. So playing music at 2 p.m, you might have to just suck it up. My neighbours used to be a fan of smooth radio. I could tell because I could hear it through the walls. But it was daytime, and you know what, I probably play my TV really loud, so I had to put up with it. But if playing that music at that volume at 2 a.m, that's a lot more unreasonable. The court recognises, of course, that's when most of us sleep. It's a lot more unreasonable to put up with that sort of thing at night. Duration, the more often it happens, the longer it goes on for, probably the more unreasonable it is. So, you know, if someone has their TV blasting for half an hour for their favourite programme, it's probably not the worst thing in the world. It's probably reasonable for you to expect to put up with that. But the longer it goes on, if it's weeks, months, then it becomes more and more unreasonable. Now, it has to be kind of more than a one-off. So a one-off party is not good enough. And we saw that in the case of Bolton versus Stone, where the cricket ball had only been hit over the wall something like 6 times in 30 years. That's not really that often. And if you live near a cricket grounds, that's kind of reasonable for you to put up with 6 times in 30 years. So have a look at the duration, and it can also be stop-start as well. So it doesn't have to be one continuous drone. So for example, if the noise is every night, stops during the day, starts the next night, you could sue for that as well. Same as if it, you know, even if it's for a temporary period. So if you think of like building work, if building work is going on near a hotel, for like, which happened in Spicer Brothers, if it was going on for say 6 weeks, but then it stopped, that still could be a nuisance because it's still ongoing for 6 weeks. Then we have to look at the extent, and I already touched on this when it comes to the interference. So property damage is unreasonable. If it's loss of amenity, then the more it interferes with your life, the more restricted your life is, probably the more unreasonable it's going to be seen as. So those are kind of the main factors that will guide the judge to decide, was it reasonable for you to put up with that? And then there's just another couple of things that we might need to look at. So one thing they'll take into account is the sensitivity of the claimant themselves. So it's kind of like the opposite of the thin skull rule. So if noise is annoying you, particularly annoying you because you have sensitive hearing, the law sees that as your problem. Is it reasonable for other people to put up with? If it is, you can't claim just because you're affected worse. It seems very, very strange. We saw this in the case of Robinson versus Kilvert, where the steam from the floor below caused damage to the claimant's paper products they were making. They weren't able to claim because that steam wouldn't normally affect any other business. In the case of Network Rail versus Morris, Morris had a recording studio that was affected by the electronic interference from nearby rail equipment. Nobody else was bothered by that interference. Nobody else heard that noise, so therefore Morris has to put up with it. Now that is really unbalanced when we're talking about the law of give and take. We're saying put up with it, put up with it. It's your fault it's affecting you so badly, so put up with it, which is of course not something we see under the thin skull rule in, say, negligence law. Also, of course, in Network Rail versus Morris, they would have had statutory authority anyway because it involved a railway. So by law, they're allowed to be there and do what they need to do to make sure the rails run smoothly and efficiently. The last thing that I want to talk about is malice. Now, malice is one of my favourite things, and malice works in 2 ways. So one thing to think about is acting in malice tends to be an unreasonable thing to do. So in Hollywood Silver Fox Farm versus Emmett, the farmer was firing a shotgun purely to try and freak out the silver foxes in the farm next door. The reason he wanted to do that was because it was the scare would stop them breeding. So he was just doing that to be malicious. Whether you agree with what he was doing or not, he had malicious intentions towards the fox farm. So he didn't have a valid reason for shooting a shotgun, which might be reasonable given it was in a rural location, but he didn't have a good reason. He was just shooting it, he was just firing it to try and scare the foxes. So that was out of malice, and therefore it was unjustified. So if you do something without good reason just to be nasty, the court isn't going to be on your side. Also, an important lesson just to remind ourselves when it comes to nuisance is that if you retaliate, you could end up being the source of a nuisance claim yourself. So in Christie versus Davy, a man was getting really annoyed about a music teacher's music lessons bothering him, so he started banging pots and trays for no reason, just to make more noise than her. You're making noise, I'll make more noise. You're annoying me, I'll annoy you. And actually the music teacher sued him and won because he had become an even worse nuisance. So the moral of the story, of course, is that if there is an indirect, unlawful, intentional interference with the enjoyment or use of land that belongs to you, you have to go to the courts to get the rightful remedy. You can't take the law into your own hands and start making just as much noise or more as them. I hope that makes sense. I hope it's quite straightforward. Thank you for listening.